Fees to be paid by workers. Any person applying with a private fee charging employment agency for employment assistance shall not be charged any fee until he has obtained employment through the effort or has actually commenced employment. Such fee shall be always covered with the appropriate receipt clearly showing the amount paid. The Secretary of Labor shall promulgate a schedule of allowable fees. Article 32 Labor Code as amended. So kapag nag-apply ka sa isang private fee charging employment agency, ay meron kang fee na babayaran sa agency nila. Pero before mo bayaran yun is dapat ma-receive mo muna or matanggap mo muna yung tulong nila para sa employment mo sa ibang bansa. Section 8 of Omnibus Rules and Regulations implementing the Migrant Workers and Overseas Filipinos, RA 8042, also provides all fees for services being charged by any government office or migrant workers as of 7 June 1995 shall not be increased. All other government agencies in connection with the recruitment, introduction and placement of and assistance to migrant workers shall be rendered free. The administrative cost thereof shall not be borne by the worker. The migrant workers are exempt for the payment of travel tax and airport fee upon proper showing of overseas employment certificate issued by POEA. Whereas Omnibus Rules implementing the Labor Code, particularly Section 29, 30, 31, and 32 of Rules 5 thereof likewise provide. Section 29, Placement Fee. A licensed private recruitment and placement agency or PRPA may charge worker placement fee which shall not exceed 20% of the worker's first month's salary. In no case shall such fee be charged prior to the actual commencement of employment. Sa Section 29 placement fee, ang babayaran ng worker sa kanyang agency is 20% of the worker's first month's salary. So, ibig sabihin kahit tataas yung sweldo niya sa mga susunod na buwan is doon pa rin magbe-base sa first month salary. Section 30, Service Fee. A licensed PRPA may charge employers a service fee which shall not exceed 20% of the annual basic salary of the worker. In no case shall the service fee be deducted from the worker's salary. So, dito naman, pagdating naman sa service fee is 20% naman ng annual basic salary. Ibig sabihin 20% ng isang taong buong sahod ng isang worker yung babayaran niya. Section 31, Transportation. Transportation expenses of the worker from the place of origin to the place of work shall be charged against the employer and shall in no case be deducted from the worker's salary. So, sabi dito na yung sa Section 31 na ang transportation ng worker papunta dun sa ibang bansa is naka-charge niya sa employer. So, wala na siyang babayaran. Section 32, Insurance of Official Receipt. All payments made or fees collected by a licensed agency shall be covered by an official receipt indicating the amount paid and the purpose of such payment. So, dito sa Section 32 is dapat daw lahat ng fees na babayaran mo sa agency is may receipt. Report on employment status. Whenever the public interest require, the Secretary of Labor may direct all person or entities within the coverage of this title to submit a report on the status of employment including job vacancies, details of job requisition, separation from jobs, wages, other term and condition, and other employment data. Article 33 Labor Code as amended. So dito is kailangan lang gawaan ng report kung ano man yung status ng employment ng isang worker.
Good day everyone. I'm Jessa Pingkian from SBA HRDM 3B. Prohibited practices. It shall be unlawful for any individual, entity, licensee, or holder of authority. Number 1. To charge or accept directly or indirectly any amount greater than that specified in the schedule of allowable fees prescribed by the Secretary of Labor, or to make a worker pay any amount greater than that actually received by him as a loan or advance. Upang singilin o tanggapin direkta o hindi direkta ang anumang halagang mas malaki kaysa sa tinutukoy sa schedule ng mga pinahihintulutang bayarin sa itinakda ng kalihim ng paggawa o pabayaran ng isang manggagawang anumang halaga mas malaki kaysa sa aktwal na natanggap niya bilang utang o paunang bayad. Number 2. To furnish or publish any false notice or information or document in relation to recruitment or employment. Upang magbigay o mag-publish ng anumang maling paunawa o impormasyon o dokumento na may kaugnayan sa recruitment or trabaho. Number 3. To give any false notice, testimony, information, or document, or commit any act of misrepresentation for the purpose of securing license or authority under this code. Upang magbigay ng anumang maling paunawa, testimonya, impormasyon, or document o gumawa ng anumang gawa ng maling representasyon para sa layunin ng pag-secure ng lisensya o otoridad sa ilalim ng kodigong ito. Number 4, to induce or attempt to induce a worker already employed to quit this employment in order to offer him to another unless the transfer is designed to liberate the worker from oppressive terms and conditions of employment. Upang himukin o tangkaing himukin ang isang manggagawang nakatrabaho na uminto sa kanyang trabaho upang ialok siya sa iba maliban kung ang paglipat ay idisenyo upang palayain ang manggagawa mula sa mapang-aping mga tuntunin at kondisyon ng trabaho. Number 5. To influence or to attempt to influence any person or entity to employ any worker who has not applied for employment through his agency. Upang impluwensyahan o subukang impluwensyahan ang sinumang tao o entidad na huwag gumamit ng sinumang manggagawa na hindi nag-apply para sa trabaho sa pamamagitan ng kanyang ahensya. Number 6. To engage in the recruitment or replacement of workers in jobs harmful to public health or morality or to the dignity of the Republic of the Philippines. Upang makisali sa pangangalap o paglalagay ng mga manggagawa sa mga trabahong nakakapinsala sa kalusugan ng publiko o moralidad sa dignidad ng Republika ng Pilipinas. 7. To obstruct or attempt to obstruct inspection by the Secretary of Labor or by his duly authorized representative. Upang hadlangan o tangkaing hadlangan ang inspeksyon ng kalihim ng paggawa ng kanyang otorisadong kinatawan. Number 8, to fail to file reports on the status of employment, placement, vacancy, remittance, or foreign exchange earnings, separation from jobs, departures, and such other matters or information as may be required by the Secretary of Labor. Upang mabigong maghain ng mga ulat sa katayuan ng trabaho, mga bakante sa pagkakalagay, pagpapadala ng mga kita ng foreign exchange, paghihiwalay sa trabaho, pag-alis at iba pang mga bagay o impormasyon na maaaring kailangan ng kalihim ng paggawa. 9. To substitute or alter employment contract approved and verified the Department of Labor from the time of actual signing thereof by the parties up to and including the periods of expiration of the same without the approval of the Secretary of Labor. Upang palitan o baguhin ang mga kontrata sa pagtatrabaho na inaprubahan at pinatunayan ng kagawaran ng paggawa mula sa oras ng aktwal na pagpirma nito ng mga partido hanggang sa kasama ang mga panahon ng pag-expire nito nang walang pag-aproba ng kalihim ng paggawa. 10. To become an officer or member of the board of any corporation engaged in travel agency or to be engaged directly or indirectly in the manage of a travel agency. Upang maging isang opisyal o miyembro ng lupon ng anumang korporasyon na nakikibahagi sa ahensya ng paglalakbay upang maging direkta o hindi direkta sa pamamahala ng isang ahensya ng paglalakbay. 11. To withhold or deny travel documents from applicant workers before departure for monetary or financial consideration other than those authorized under this code and its implementing rules and regulations. Upang pigilan o tanggihan ang mga dokumento sa paglalakbay mula sa mga aplikanteng manggagawa bago umalis para sa mga pagsasaalang-alang sa pananalapi maliban sa mga pinahihintulutan sa ilalim ng kodigong ito at sa mga tuntunin at regulasyon sa pagpapatupad nito.
Assalamualaikum sir, this is Anwar Sionga and today I'm reporting the suspension and or cancellation of a license or authority. Suspension and or cancellation of a license or authority. Any of the following shall constitute as a ground for suspension of a license authority. 1. Violation of any provision of Section 7, 13, or 14 of these rules. It is unlawful for an employer to interfere with, restrain, or coerce employees in the exercise. For example, employers may not respond to union organizing, drive-by threatening, interrogating, or spying on pro-union employees, or by promising benefits if they forget about the union. 2. Violation of Department Order Number 21 Series of 1994 regarding publication of job vacancies. There must be showing that the employer become unfit to continue working for the employer. 1. There must be disobedience or insubordination. And 2. Disobedience or insubordination must be willful or intentional, characterized by a wrongful and perverse attitude. Non-insurance of a official recipe for every fee collected. For example, failure to issue recipe, 10,000 for the first offense and 20,000 for the second offense. Non-submission of monthly report as provided in Section 6 of these rules. 5. Charging or accepting direct directly or indirectly any amount in excess of what is prescribed by these rules. Private fee charging employment agency means any person or entity engaged in recruitment and placement of workers for a fee which is charged placement. uh, Number 5, charging or accepting directly or indirectly any amount in excess of what is prescribed by these rules. Private fee Private fee charging employment agency means any person or entity engaged in recruitment and placement of worker for a fee which is charged directly or indirectly from the workers or employers or both. Disregard of lawful orders and notice issued by the secretary or of as duly authorized representative. 7. Non-observance of the procedures for recruitment as stated in Section 20 of these rules. Section 33, Rule B1, Omnibus Rule Implementing Labor Code. Grounds for cancellation, revocation of a license. Any of the following shall constitute a ground for cancellation or revocation of a license. 1. Violation of the condition of the license. Let's for example, the driving. Reckless driving, drunk driving, and distracted driving are violation of the law in themselves. They need to result in damage, injuries, or even death for them to be punishable. Engaging in act or acts of mispresentation for the purpose of securing a license or renewal thereof. 4566, an act creating the Philippine Licensing Board for constructors, prescribing its powers, duties, and function, providing funds therefore and for other purpose. 3. Continuous operation despite due notice that the license has expired or incurring to suspension of a PRPA based on the final executory order. 5. Engaging in a labor only contracting as defined in Article 106 of Labor Code as amended 6 recruitment and placement of worker in violation of RA 7610 as amended by RA 7658. Transferring, convey, or assigning of a license authority to any person or entity other than the one in whose favor it was excused and violation of any of the provision, particularly Article 34 of the Labor Code, as usually amended, and it is implementing rules and regulation. Section 34, Rule 6, Omnibus Rules Implementing Labor Code as amended. The implementing rules and regulation shall cover all the mandated function and duties of the Philippine Competition Commission to facilities the implementation of the provision RA 10667, otherwise known as the Philippine Competition Act, and all employers shall adopt the model contract in connection with the hiring and engagement of the service of overseas worker. The implementing rules and regulation shall cover all the mandated function and duties of the Philippine Competition Commission to facilitate the implementation of provision RA 10667, otherwise known as the Philippine Competition and all employers shall adopt the model contract in connection with the hiring and engagement of the service of overseas worker. Sukran.
Good day, everyone. Authority to suspend or cancel license. The regional director who issued the license shall have the power to suspend or cancel the license. Section 53, Rule 6, Omnibus Implementing Rules, Labor Code as amended. So, ang regional director ay maaaring magpawalang bisa ng isang license dahil sila rin ang gumawa nito. Ang isang license ay binabawi kapag ito ay ginagamit sa isang illegal na transaksyon. Next, effect of suspension or cancellation of license. An order of suspension or cancellation or revocation shall have the effect of suspending or terminating all activities of the agency which fall under the definition of recruitment and placement. The regional office may seek the assistance of the government institutions, agencies, or offices to ensure that the suspension or cancellation orders are implemented. Section 54, Rule 6, Omnibus Implementing Labor Code as amended. So, hindi mo magagawa ang mga aktibidad na kinakailangan ng transportasyon dahil iyon ang epekto ng pagsususpinde ng iyong license. At para masiguro nila ang epekto ng kanilang pagkakasuspinde, hihingi sila ng tulong sa ibang ahensya ng gobyerno para matiyak na ito ay maipapatupad. Appeal. The decision of regional director is appealable to secretary within 10 working days from the receipt of copy of the order on any of the following grounds. In law, ang appeal ay ang proseso kung saan ang mga kaso ay sinusuri ng isang mas mataas na awtoridad kung saan ang mga partido ay humihiling ng formal na pagbabago sa isang opisyal na desisyon. Ang mga appeal ay parehong gumagawa bilang isang proseso para sa pagwawasto ng error, pati na rin ang isang proseso ng paglilinaw at pagbibigay kahulugan sa batas.
Assalamualaikum sir, I am Ramzy Lilan from Bachelor of Science in Business Administration, major in Human Resources Management. So proceed na tayo sa report ko. So first is suppletory application of the rule of court. In the absence of an applicable provision of this rule, the pertinent provisions of the rule of court may be applied in a suppletory character. Section 55 Omnibus Rule Implementing Labor Law as amended. So, suppletory application of the rule of court. This regulation shall primarily govern in the prosecution of administrative complaints in the Bureau. The provisions of the rule of court, however, shall apply in a suppletory character. So next is regulator power. Regulator power. The Secretary of Labor shall have the power to restrict and regulate the requirement and placement activities of all agencies within the coverage of this title, and is hereby authorized to issue orders and promulgate rule and regulation to carry out the objective and implementing provisions of this title. Art 36 Labor Code as amended. So, regulator power are the power used by government agencies and regulators to ensure individual and industry comply with legislative requirements. And the last one is visitorial power of the Secretary. The Secretary of Labor or his duly authorized representative may at any time inspect the premise, books of accounts, and records of the person or entity cover violations of any provisions of this title. Art 37 of the Labor Code as amended. So the visitorial and enforcement powers empowered the Secretary of Labor and Employment or his or her authorized representative. So assist the employer records and premises at any time of the day or night so long as work is being undertaken. Issue compliance order to give effect the labor standard. That's all. Thank you.